All right, you ready? There is a big trial going on in Michigan. Issues of race, stand your ground, colliding once again. This time, it's taking place in Detroit, Michigan. All right, so here's what we know. 54-year-old white man, Theodore Wafer. Why am I saying he's white? Well, because the victim, 19-year-old black woman, Renisha McBride. He shoots her on his porch in the middle of the night. Quick fact pattern. It is the middle of the night. He is asleep, pounding on the door. Bang, bang, bang. He gets up. He doesn't know what's going on. Here's again, bang, bang, bang. Goes to the door, opens it, sees a shadowy figure, he says, moving off the porch. A shooting occurs. First he says it was an accident. Didn't mean it. Didn't think the gun was loaded. Then it becomes a self-defense case. What do we know about McBride? 19, had crashed her car, had been partying, assumed she was looking for help. That was not his assumption. All right, that's the fact pattern. What's the analysis? We have legal analyst, former federal prosecutor Sonny Hostin, and legal analyst Danny Cevallos, criminal defense attorney. All right, so let's start at the beginning here. Sonny, you're undecided, but on the facts as we understand them,
sure.
The first curious thing, self-defense, accident. How do you get both of those and be consistent?
You know, I think it's going to be difficult, quite frankly, for that fact pattern for the defense, because initially he said this was an accident, didn't even know that the shotgun was loaded, and then now he's saying actually this was self-defense because I feared for my life. So I think that's certainly an inconsistency. But I've got to tell you, after listening to opening statements yesterday, we heard two very, very different stories. We did hear sort of this compelling story about a man woken up at 4:30 in the morning, hearing banging on a side door, then hearing banging on the front door, not being he doesn't have a landline, can't find his cell phone, approaches the door with a shotgun. On the other hand, we heard from the prosecution, which I also thought was rather compelling, which is why, Chris, I'm so undecided. We hear that he shoots through a locked front door and he is secure then in his home. So I think the real question is, in terms of how do you protect yourself when you're in your home? Where are the legal boundaries? Is it on the front porch? Is it inside of your home? Can you protect yourself if you're in your garage? And I think that's really going to be the question here.
Danny, does stand your ground laws come into play here?
In a way, Michigan is one of those states that has really two sections that deal with this. The first section is basically self-defense. And in Michigan, you must honestly believe you're in apprehension of imminent serious bodily harm. But a second section says that if you are in a certain place like your home, then a presumption arises. And that presumption is that your use of deadly force, your apprehension, your honest belief of fear for your bodily injury is a reasonable one. And that presumption can be overcome. But that's an example of a kind of stand your ground, that while you're in your house, you get the benefit of that presumption that your fear is real.
So given that, it sounds like this case would meet that standard.
It does initially, but then you have to look at some of the inconsistent statements that he gave. And it is true. In fact, in 2001, a federal court in Michigan did suggest that a jury can be instructed on accidental self-defense in a way. In other words, a defendant pulled his gun in reasonable fear of danger, but then after that, it went off accidentally. I should add that in other courts in the country, they have rejected this idea of accidental self-defense.
It's rejected a lot more than it's accepted. Tell them why, Danny.
Yeah,
Tell them why.
It's logically inconsistent.
That's right.
As is the word honestly believing you were reasonably makes sense. Reasonable is something all lawyers are taught. It means that under the circumstances, this is what a common person would do. Honestly believing it is, you know, very difficult to test.
And I think that's really going to be the question here. What would a reasonable person do in the situation? And during jury selection, there were a lot of questions about race, and I think that is also going to come up.
Do you think they're legitimate questions?
I think they are legitimate questions.
Why?
Because we're talking about
through a locked door. How did he know what color the person was?
Well, he claims that he saw, I think initially when this case broke, he did make statements about seeing a black person.
Black or shadowy?
Shadowy, yes, but also a black person on his porch. And so I think that is why the jury was questioned about it. We know that there are 4 black jurors on this jury. The jury was questioned about race, and I think it's going to be front and center here.
We're talking about his case. The lawyer, as Sonny said, did do a good job in raising some issues. Let's take a listen to what his lawyer had to say, the defendant's lawyer.
Boom, 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 boom! He is awoken. He is like the hairs on his arms, and he looks out at people, and he sees a shadowy figure coming off the porch and going around the side of the house. That's all he sees, a figure. He knows it's a human. And at this moment, because of the side and the front, he thinks it's not one person, it's 2 or more people.
Danny, what do you think of that argument? It makes sense that he would be scared out of his mind when you hear it depicted that way.
That's a terrific example of an opening. There's a lot of theater there, and the defense attorney focuses on putting the jury there. It's one thing to say, hey, I heard something go bump in the night. It's another thing to shout those words over and over again and put the jury there, imagining if they woke up at 4 in the morning. And the defense attorney wants the jury to be thinking about, how would you think if you hear a pounding at 4 in the morning?
Yeah, but when's the last time you had an intruder knock on your door? You know, she says boom, boom, boom like they were gunshots. It's someone knocking on the door.
It's someone knocking on the door. Yes, on the side door, and then again on the front door. But for me, I think, and I think this is going to be very difficult for the jurors, why do you then shoot through a locked door? You were in the security of your home. And again,
did he ever say anything? Did he ever reach out? Did he try to identify who was there?
Apparently not.
But he thought they were breaking in.
He thought they were breaking in, but the bottom line is they had not. No one had broken in. He was still secure.
Signs of breaking.
Exactly,
Right.
still secure
But
in his
still,
home. And I think
that's the fear.
I think that's going to be the argument. Can you protect yourself from inside of your home by shooting someone outside of your home? I think it's unreasonable. I think that's why the government brought this case. I think, you know, that the question is going to be close, but this is a seminal case. This is a really important case because it really will draw the line as to how you protect yourself. Can you protect yourself from inside of your home? I think it's going to be fascinating.
Now, what we left out of our analysis today, because the trial is still new, obviously we just had openings, is a lot of information about her as well. Not like character information, but what had been going on that night that could come into play about how she was behaving and how she should have been perceived. At a minimum, it's not so much about just state of mind, but just where she was coming from entering into this situation, which he couldn't have known, but may come into play in terms of judging.
But to your point,
I'm being a little vague, but I mean, you know, they have to lay out the case before we judge it.
Right. We you know, it's been reported that she was drinking, had smoked some marijuana, and got into a car accident, crashed a car. But that was 3 hours before this incident. So, you know, 3 hours is a pretty long time in terms of whether or not you're still under the influence.
Right. Well, to be fair, she was playing a drinking shot game with hard liquor and smoked a pretty sizable blunt. So
but you're still
3.5 hours later.
In the face,
but then,
but I mean, let's not paint it like she was at a cocktail party clinking wine glasses. I mean,
this is why.
But does that matter?
See, and that's why I left it out of this.
I don't think it matters whether or not she was at a cocktail party, Danny. But I think 3 hours, going past is significant in terms of intoxication.
But I want to wait to see how they lay it out. That's why we were time tight, but I wanted to leave it out of this segment because let's see how they use it. And then we'll judge how prosecutor and defense use it.
It's always very dangerous to character assassinate.
It's true.
For
That's why you shouldn't do it to me as often as
you usually deserve it, though.
That is true.
Good point.
Fair point.
Sonny, Danny, thanks so much.